I'm Callie Waterhouse with the Arizona Association of Realtors, and we're excited to welcome Mary Frances Coleman with us here today. She is a real estate attorney, a realtor, and now the brand new vice president over at Realty Executives Arizona. And today she's going to be talking about RESPA do's and don'ts. And as we know in real estate, RESPA is a hot topic. And right now, with all of the TRID and the CFPB changes coming on, it's really just on fire. So we are thrilled to bring today's webinar to you. And we're going to have a presentation today about 45 minutes, maybe a little bit longer. Mary Frances is going to mix it up a little bit and do some Q&A during today's presentation. So please use the question box feature on your screen. Ask questions. So Mary Frances, welcome to today's webinar.
Thank you. Very, very happy to be here, and a pleasure as always to help out the association and its members.
Well, we are thrilled. And so we know that everything is working today. We're just going to jump right in because this is a ton of good information. And I know it's one of my favorite topics. I'm a very black and white person. So if you tell me the rules, I want to know the rules. And I know our members feel the same way to protect our businesses, our brokerages.
Sure.
So we're just going to jump right in. So welcome, welcome. And the floor is all yours.
Thank you. And that's an interesting comment because if you know the rules, we'll follow them. The amazing thing about RESPA is that the rules have been in place for a very long time, but nobody was following them. Right. So nowadays, we're starting to follow them because the Consumer Financial Protection Bureau now oversees RESPA, and they are enforcing a lot of different RESPA violations. So if we can go over how long RESPA's been there and all the rules that have been in place ever since to start, I want to make sure that everyone understands nothing has changed as far as the violations and things we can and cannot do. It's just that they're being enforced now and that there's a higher group evaluating and looking at and investigating all of our violations. So as you can see on your screen, RESPA's been around since 1974. And it always surprises me how many of us out there don't know what RESPA stands for. So there it is for you on the screen. It's the Real Estate Settlement Procedures Act. And it was enacted basically as a disclosure and anti-kickback statute. So in the 70s, we were very much starting the ball rolling on consumer awareness and Ralph Nader and consumer protection. And that's what really led to the enactment of RESPA. And it was designed to serve what is on your screen, the 4 primary purposes. It required disclosures that gave settlement costs to buyers and sellers so they knew exactly what they were paying for instead of a total dollar amount. It eliminated kickbacks and referral fees, which tended to increase the cost paid by consumers as the members that would be on settlement service providers and are bound by RESPA were referring things back and forth or pushing consumers into one direction to use one of the affiliated industries. What it did was try to avoid that or eliminate those high fees by what number 1 said, listing all the settlement costs to the home buyers and sellers. The third thing it did was reduce the amount that home buyers have to place in escrow accounts and give us a good understanding of what happens to that money when they do. And the 4th primary purpose was to reform and modernize record keeping and land title information, which you can imagine in 1974 was quite laborious because there was no such thing really as technology back then. So it was all done by hand, and records were kept in files and filing cabinets and big, large boxes, and nowadays it's much more expedient. So those 4 primary purposes really came to be in 1974 in order to protect the consumer. And the good thing about that was that it created kind of an open door, open transparency as to what we do. The bad thing about that is it then brought to light all of the things that we were doing for our own benefit and not the consumer benefit. So if you look on the screen, then I'm going to show you who is bound by RESPA, because sometimes we have issues on really who gets involved with it. So RESPA applies to settlement services. And right now we look at settlement services under really the HUD-1 settlement statement, which was created a few years prior. And we all know that that's going to change with the closing disclosure replacing the HUD-1 settlement statement. But the parties involved in settlement services are not changing. So when we think of settlement services, we kind of picture the HUD-1 in our heads, which is going to be different. So don't confuse the fact that the closing disclosure is replacing the HUD-1 and perhaps it's replacing some of the people who are bound by RESPA. It is not. Those people are still represented on the new closing disclosure. So what we talk about is who is included and all of the things that happen on or before the closing of a home that could or potentially be violating RESPA. So here's kind of what a settlement service includes. You've got a gigantic list there, but these are also the people that are governed by RESPA. But it includes us, obviously, title insurance companies and escrow companies, lenders and brokers and bankers, processing funding of a loan. Attorneys are bound by RESPA as far as settlement service providers. In attorney states, for example, they're always on the settlement statement. Credit reports, appraisers, home warranty companies, insurance companies, anything that would be charged on that settlement statement or on the closing disclosure falls under really the auspices of RESPA for violation and do's and don'ts purposes. So does anyone have any other providers of a settlement service that you think would fall under the scope of RESPA that's not listed here? Go ahead and type that in if you do. You'd be surprised at how many things people come up with, although these are really the big ones. Well, I'll tell you, some of the other things that I get questions on are like people that we give gifts from to our clients. If I buy a Starbucks gift card, how does that affect RESPA? Well, if it's our client, it might not. Of course, Starbucks is not under the auspices of RESPA because they're not on the settlement service statement. But if I have a pool company and there's a holdback and that pool company gets paid out of escrow, would that person be bound by the RESPA service laws? Not really, but they are on the settlement statement. So what we're talking about are people who are absolutely a service provider with all things associated with the purchase of a home that occur at or before settlement. We have a question here.
Okay, so the question is, so why would marketing and photography show up on the settlement statement?
And many times they won't because we're paying for those out of our pocket, but that doesn't mean that we might not be violating RESPA. Let's say, for example, and we're going to get more to these in the do's and don'ts. Let's say I'm a realtor. I'm on the settlement statement. I use a lender a lot. They are on the settlement statement, right? So I'm not talking about our services that are showing up on the settlement statement. I'm talking about the fact that we are settlement service providers. So if I pay my lender $100, thanking them for referring me the client they did, that's a violation of RESPA because we are service providers. Marketing, when you put ads in the Republic, when you buy a gift card, those people aren't settlement service providers, but the act of what you're doing might violate RESPA if it's including another service provider. Hope that one makes sense.
So what about free printing?
Free printing and marketing, you guys are jumping right into the questions and answers, which is awesome. That's fine with me. That's what we're here for today. I'm going to give you the lawyer answer and say it depends, which everybody hates to hear, but it's the actual truth. If we can skip ahead a couple slides, I want to explain what this means. Wait, go back, sorry.
This one?
Okay, this one. If you can see this slide, Section 8A of RESPA prohibits a person from giving or receiving any fee, kickback, or thing of value pursuant to any written or oral agreement or understanding that business involving a real estate settlement service and a federally related mortgage loan will be referred to any person. So I know that's a long sentence because most litigation and legislation is long. But I will tell you, here's what that basically it means. There's really 4 elements that are required for a Section 8A violation. Number 1 is it has to involve a federally related mortgage loan. There's a loan secured by a first or subordinate lien on a 1 to 4 family residential dwelling. And it means any loan that places a lien on a property like that, including government insured and conventional mortgage loans. So, does RESPA apply, everybody answer if you can, to a cash sale? What do you think? Give me a yay or nay in your answers.
Looks like we've got the lawyer answers. It depends.
So, according to this, no, right? Well, yeah, really, settlement service providers involving a federally related mortgage loan can violate RESPA. So here's what I'm going to tell you. There's a lot of things we're going to talk about today that's supposed to happen and what really happens. Typically, a violation only occurs if there's a federally related mortgage loan secured in it. That doesn't mean that you can go out on all your cash sales and violate what would normally be a RESPA violation because it's a cash sale. I would not delineate your transactions that way, nor would I allow, if you're a broker, your agents to do that. But what happens when you do that is you're running the risk of standardizing that practice. And most of us are violating RESPA and don't know it right now. So as we get back to the free printing and marketing question, if we go through these next 4 things, I want you to remember that the actual RESPA Act says services involving a federally related mortgage loan. The second criteria says a referral of business incident to or part of a settlement service pursuant to an agreement or understanding. This does not have to be in writing. It can just be implied by conduct. When we're talking about something like this, it means that if I refer business to somebody that is a settlement service provider, and I expect them to refer business back to me and vice versa, that could be one of the elements for a violation. So we've got to make sure that even though we're not writing things down or we're not saying we have a marketing service agreement or affiliated business agreement, just our conduct could establish that we're doing that. And there's a, wink, wink, nudge, nudge understanding that we're going to refer business to each other. The third element, this is the one that we're talking about. Payment or receipt of a fee or thing of value. So a thing of value is anything anybody receives in consideration for referring a settlement service. Let's look at all of these things. Most of these, and by the way, this list is provided by HUD. Money or fees, discounts, payments of a charge, distribution of profits, credits, money-making program participation, special rates, rental payments in the amount of the business referred, or trips and payment of another person's expenses. So what it doesn't list here is marketing and advertising, but it really is money or fees or the diversion of another person's expenses. So that's where we get into the trouble or the trap of did we violate or did we not violate RESPA. So 3 and 4 is really, these elements, 3 and 4 are really where we're focusing. The payment or receipt of a fee or a thing of value in exchange for the referral of settlement service business. So what that means for our purposes is if I'm an agent and I expect my title company to print all of my marketing materials for me for free, and in exchange, I will give them all of my escrows, that's a violation of RESPA. It's very clear. They cannot do something and give me something that's valuable to me in exchange for the referral of business. Now, I say that, but in reality, it happens all the time. It's going on as we speak. Somebody's violating RESPA. So it's hard for us to digest that we're not supposed to be doing that, because the answer I get all the time is, well, everybody does it and everybody's done it forever. And that's the truth. But since 1974, we were not supposed to be doing this. And we kind of ran amok in the 90s. And in the 2000s, when business was good, nobody was going to step in and stop these practices because it would put the brakes on our business. After the market crashed, and now with the creation of the CFPB, we're going back and getting evaluated. That's why right now all your title companies, many of your lenders, are stopping what they used to do for you for free all of the time. They just can't do it anymore. So one of the other questions I get is, what about CE classes? Get this all the time. I teach a lot of CE classes. Can a title company or a lender sponsor a free CE class? And the answer is really no. They cannot. They can sponsor a class as long as they are there advertising their services to you when you attend, but they cannot pay for it for you. So that's a thing of value to you. Continuing education is a requirement for your license. So for them to pay for it would be giving you a thing of value, basically in exchange for your business back to them. That's what they're doing. If they're just advertising their services or their wares to you and you paid to attend the class, that is not a violation. The paying for your class is the violation. And we're seeing that a lot. As a matter of fact, if any of you are licensed in any other states, you'll know, like California, for instance, you won't even see anybody in your CE class that is not the teacher or the students. There's a prohibition under California regulation that you can't have sponsors coming in advertising and marketing during continuing education classes. So some states have actually outlawed it through regulation, and there's no issue. We still deal with it a lot here. That's a big one.
Do you think we're headed in that direction?
Well, we don't even need to be headed in that direction because it's the rule already. So it's funny to me that we had to enact more regulation to clarify the regulation, right? We're a very heavily regulated industry already. We need to just kind of follow the rules that are already in place. But the CE class one is one that I get all of the time. Now let me piggyback on that one. What about a class or an informative lunch and learn that's not for CE? What do you guys think? Give me an answer. Do you think a lunch and learn that is free to you and that a title company pays for and brings lunch in to you would violate RESPA? Give me a yay or nay. We're getting some answers.
Yes, and depending.
Yes, and depends.
Mary Frances, just so you know, we have kind of an eclectic group of members on today. We do have some title people.
Ooh, awesome.
On today, so
Okay.
maybe if you have questions for them, or I don't want to put them on the spot.
No, that's great. That's great, because part of the issue with the industry is that we don't all know what each other does, and realtors definitely have expectations of title. Like the Industry Partners Conference that's coming up September 16th is a great example. We need to work together as an industry, not point fingers and why aren't you doing this or you were supposed to do this. So it's great to have a different group in here because there's a different perspective. Mm-hmm. But to answer that question, to a lunch and learn without CE was just informative that a title company would be putting on for agents is really not a violation of RESPA. And they can be advertising their services as well during that. Because even though we think it's a thing of value, meaning it's education, it's not replacing a required continuing education class for our license. It's just an informative seminar. So that's not really a violation of RESPA. And it's interesting, let me tell you, I could leave right now and bring another lawyer in or bring somebody else in to have the same webinar for the next hour, and you'll get totally different answers. And the reason why you'll get different answers is because nobody's really sure. Nobody's ever enforced this before. So now we're kind of going back to square one and trying to figure out what we can and cannot do. But HUD's actually been very clear on that, and they said exactly that if it's not replacing a required education or a thing of value, then it doesn't necessarily fall under the auspices of a RESPA violation. That's a good one. I get that one a lot. Since we have such a diverse group, I'm wondering if you guys, while I'm talking, can type in some questions that you have of me, and I'll get to them as we keep going. Oh, look, that was fast. Holy cow.
What if the lunch and learn is directed to one real estate agency?
To a specific brokerage? Mm-hmm. I'm not sure that would even be a violation. It's again, providing an informative session. It's not replacing continuing education. If it were a CE class, it would definitely be a thing of value. If it's simply a lunch and learn with no credit, HUD's said over and over again, it's not a RESPA violation, even if it's for just a specific brokerage. Now, if that brokerage and you have a marketing services agreement or an affiliated business representation, we might have different issues, but that is only going to be if the agents who come to those lunch and learns continuously are told over and over again, and use us because you'll get something back for it. You know, we're providing these for you because we want you to use our affiliated business arrangement and use our services. I think it's kind of unspoken, but that might be where it gets a little hairy. But if it's a straight lunch and learn, even if it's for a specific brokerage, it should not be considered a RESPA violation, because you're providing value in education, but not something that replaces what is a cost usually to the agent. Any others before we keep going?
Let's change out the words lunch and learn to office meeting.
Okay.
If a title company wanted to bring lunch to a brokerage's office meeting.
Sure.
Violation?
Well, here's the thing. Nothing's ever a violation if you are advertising your services. If I am coming in and bringing you a whole bunch of stuff and I get time to tell you what I do, why I do it, how it can benefit you, it's really not supposed to be a RESPA violation. Here's the thing. Again, I'm going to just say it straight out because we get confused a lot. If it's a requirement that you use me, or if I'm doing this only for you because you refer me business right now, that might be seen as a RESPA violation. So let's take it out of the office meeting situation and put it into you open escrow with the same title company as an agent. You're loyal to them, you always ask for them, and you continuously do your escrows there. The escrow officer or branch manager there takes you to Mastro's for dinner to thank you for all your business. That's a RESPA violation. So because it's specified to you, it's in the anticipation of the continued referral of business that they're quote unquote rewarding you for giving them business. If a title company wants to take you out to dinner and tell you all about what they do and how they do it, and that's what the business is discussed at the dinner, really not a RESPA violation, but it's a very fine line, and sometimes we cross it. We've got a couple other questions. Happy hours, yeah. All this stuff, yeah. Mm-hmm. Same thing. If the vendor sponsors a happy hour, and all it says is sponsored by XYZ title, and there's no discussion at that happy hour about XYZ title and what we do and why we're bringing you this service, then it could very well be a RESPA violation. These are all these kind of we said in the beginning, tell me the rules and I'll follow them. The rules, the reason why we always have litigation in life is because laws are written and then you have to file a lawsuit to interpret the law, right? So what we're seeing now is a lot of investigations and lawsuits being filed over potential RESPA violations that are narrowing these answers for us. But HUD many, many times talks about how if companies are providing something because they're there to talk about their services and what they provide, it's really not supposed to be a RESPA violation. Does that make sense? I know that probably diverges from what you've been told, but if the happy hour is for the agents that send you the escrows, that's a violation. It's weird, I get it. And you know what? Let me ask you another question, and maybe we can get some of these, because these are things that happen to us. Here's the big one. This is the one I get all the time. Can the seller force me to use their title company? How many of you have that question? Well, we already had one, right? Wow, there was already a question before I even asked it. Okay, great. What do you guys think? Yes or no? Can the seller require the buyer to use a specific title company?
So buyer's choice, no, no, buyer's choice.
No, it depends.
If they pay for it.
All right, who is that?
That's Tom.
All right, Tom. In our contract, it is boilerplate that the seller is paying for the owner's title policy. All right? So HUD has been very clear on this. Whoever is paying for the title policy can select the title company. So time out, don't all run out and change what you say to people now. I want to explain why this is so confusing. We are not an attorney state. So in many other states where we truly separate title and escrow, in Arizona we lump them together, and a lot of agents don't know the difference between title and escrow, and they couldn't explain it if you asked them, even if they do know that they're two separate things. The title insurance is provided by the title company, the chain, the commitment, all of that. The escrow processes the transaction basically and holds the funds and is a repository for all of our funds and distributes them and makes sure the transaction is processed. It's a neutral third party. So in Arizona, we lump those together, which makes it confusing. Our contract states that the seller is, by the boilerplate, paying for the Alta homeowners policy, the owner's policy, and that the buyer is paying for the lender's policy, and that escrow fees are allocated equally. So this is where we get screwed up in Arizona. In many other states, there isn't even this issue or question because title is completely separate. But here's the bottom line. Because the seller is paying for the owner's policy, they pretty much do have the right to pick where they're buying it from, okay? The other thing that could happen here is the buyer can buy their lender's policy anywhere they want. They don't have to do it at the same place the seller issues the owner's policy. And HUD has been very clear on that. So they're not going to enforce a RESPA violation if a builder or a seller, because builders do it all the time, require the buyer to use a specific title company when they are paying for the title insurance. So huge difference from probably what you've been told. And we get a lot of arguments. I get it too in my transactions and pushback about that. But I will tell you this. The people who make this an issue are us, not the clients. We make this an issue. We are being detrimental to the transaction by causing these problems to begin with. Our clients, most of the time, as long as the costs are very similar and they're all filed, right? All these rates are filed, everyone can see them. They're not the ones demanding you use a title company. It's the agents doing it. And the reason why the agents have done it for so long is because that title company or that lender or that inspector or whoever it is has always given us stuff, things of value in exchange for the referral of business. That's exactly what RESPA is designed to prevent. So we demand you use our title company because they probably paid for a lot of stuff that they shouldn't have paid for anyway and expect the referral of business back. But in reality, the seller can choose if the seller's paying for it. There's some case law and there's some issue on the fact that the buyer's paying for the lender's policy. And some people will tell you that the seller has to pay for both policies in order for the seller to require the title company. But HUD has stated, and it's on HUD's website if you want to go look at it, that that's not the case. It doesn't require the buyer to use the same title insurance company for their lender's policy. So wherever the seller wants to buy it from, they can buy it from there. What do y'all think about that? I'm sure I'm going to get a ton of answers on that one. But NAR is a completely different answer. What does that say, Kelly?
It says interesting. NAR is a completely different take with the link.
Okay. Well, I love NAR, I love AAR, but I'm going to go by what HUD and the CFPB have put out there for this particular issue. Here's the take, and I understand why NAR is doing it. That does not mean, like I just said, that this should be an issue in our transactions. So when I told you this to start, I said, don't all run out there and change how you do things and say, oh, guess what? I don't have to take your title company, Mr. Buyer, because I want to use mine, and so does my seller. We also have to take a step back and look at what's best for the transaction and our clients. And NAR's different take on that really goes to the spirit of the transaction. And again, the fact that we make the title company more of an issue than the clients do. So we don't want to go out there and force it down everybody's throat because, as you know, there are agents who will hear this and then completely change the way they do business and write things on the MLS and write things in their offers that make it difficult. And by the way, the MLS rules also apply. And MLS does not allow you at this point to demand the use of a specific title company. So you have to abide by those rules as well. But for RESPA violation purposes, HUD has been clear, and it's right there on their website if you want to go to it, that they're not going to enforce violations if the seller's paying for the policy. So that's a big one that I get also. I had a good one that I wanted to read to you directly from HUD's website because this is something else that happens all of the time. So did you have another question?
Do you want to do these questions?
Yeah, let's do some of the questions and answers that we have here. This is kind of an easy one. An agent is sponsoring an open house for other agents. A local title agency reimburses the agent for lunch, and the title agency does not market its title services at the open house. Is that a violation?
Everybody should get this correct. Yes, straight across the board.
Well, let's click to the answer. Yes, it's a violation. They reimburse the agent for the cost, and they've given the agent a thing of value in consideration for the referral of business. It's pretty simple. But look at the however. If the real estate agent attends the open house to make a presentation, or that's wrong, sorry. If the title agency attended the open house to present their services and market its services, it may be lawful under RESPA. So it's all about marketing and being there and marketing their own services. All right, let's try another one.
Hey.
I don't have to read it. Why don't you guys read this and type in your answer, yes or no?
Okay, but for those of you who are on your phone.
Oh, sorry, I didn't know that.
Just in case, we're going to read it.
A real estate broker and a lender agree to jointly place an advertisement in the newspaper. First of all, totally outdated. Nobody puts ad in the newspaper anymore. But let's say it's a marketing piece. Each company gets 1/2 of the page to advertise its services. Each company pays 1/2 of the cost of the advertising. Is this a violation? Give me a yay or nay, you guys.
Oh, very smart. Nope, across the board.
All right, well, there's our answer. It appears to comply with RESPA, as long as they're reasonably related and they're proportional to the payments. So if one party is paying less than the pro rata share for the advertisement, then it very well could be a RESPA violation. So that goes back to the printing and marketing. If I'm the agent and I'm on 3/4 of the advertisement and the lender's on 1/4, but the lender paid 3/4 and I only paid 1/4, the opposite, that could definitely be a violation. Has to be proportionate to the marketing. Good one, you guys.
Very good. And they're quick.
They are quick. All right. We talked about this. If the owner of a title agency meets a real estate broker for dinner and the purpose is to discuss marketing opportunities, can the title company pay for the broker's dinner? Is that a violation of RESPA?
And now saying it depends. Ooh, mixed answers, yes and no.
All right, well, here's the answer. It does appear to comply because the title agency can pay for the dinner because the purpose of the dinner was related to the marketing and services, not a payment for the referral of business. So I'm not taking you out to dinner and saying, hey, I'll take you out to dinner every Tuesday night at a fancy restaurant if you give me business. I'm taking you out to dinner to tell you, here's what our company does, and we can provide a lot of tools and support and service for you and your agents, and we'd love for you to use us. But it's not related to the referral of business. It's about their services. Let me do another one for you because it's not on our question and answer, but this happens a lot too. I'm going to read this straight from a RESPA roundtable at the Tucson Association. If a real estate licensee provides tickets to sporting events to lenders who send them buyers, is it a RESPA violation?
Can you repeat that?
Yes. If a real estate licensee gives tickets to a sporting event to a lender who sends them buyers, is it a RESPA violation?
Looks like we have yes straight across the board.
Yes, straight across the board is correct. Same thing the other way. If the lender takes the agent to the Cardinals game because the agent refers the lender buyers, that's a violation. you're all freaking out right now. That happens all the time. Tickets have value. Absolutely. That's a thing of value in the expectation of the referral of business. That happens all the time, though. And not only does it happen all the time, people put it on Facebook, like, love my lender, just took me to the Cardinals game. Awesome. But you can't do that. And by the way, does anyone know how most RESPA violations get discovered? I'm going to give you a little insider hint on how the FBI and the CFPB work. I do a little consulting for them, and this is what they call it. They call it the X factor. And that means ex-employee, ex-spouse, ex-girlfriend, ex-boyfriend, new girlfriend of ex-boyfriend. They look for those people who used to work for you. Ex-employees are the biggest source of complaints and potential violations that the CFPB gets as investigations. They've been working for a company for 10 years and all of a sudden they got fired. Well, guess what? I'm going to tell the CFPB all the stuff that happens behind the scenes, and they're going to pull the string and they're going to unravel your entire business of RESPA violations. They call it specifically the X factor, and that's what it's about. It's crazy, definitely. Let me ask you this one. How about if a listing agent sends a gift to the buyer's agent after a closing, thanking them for doing the transaction? Listing agent sends a gift to the buyer's agent. What do you think? Is that a violation?
Nope. No violation. No.
Right. And that's great. It's not a violation because gifts between licensees are not covered by RESPA. It's one settlement service provider to another that's covered by RESPA. So that's great. You guys are good on that one.
So let's go back to that football question for just a minute.
Okay, sure.
So the question is, what if they went to the game and talked about business?
Yeah, okay.
So,
great question, because that's what we've been talking about. You know, the determination is really, is this your really good agent who refers you a lot of stuff? Because if that's the case, what are you really talking about at this game? You already know the services and the support and the business. So could I make an argument as an investigator that, well, how many agents did you take besides that agent? And that's a lot of what we look at if there's a RESPA violation. If you're only having a Christmas party for all of the agents that year that sent you business, but not opening it up to everybody, that could be a RESPA violation. Those are the types of things that get looked at. How did you pick that person to take? And are you really talking about business, or are you really rewarding them for the current business that they've already given? And I know it's there's not a black and white answer, there really isn't, but those are one of the things that an investigator would look at if there's an issue. What else? You guys have any other questions? Because I have a ton of questions and answers.
All right, next question. A title company helping with a broker open, bringing a cheese plate, refreshments, and then staying, and marketing with the agents that attend.
Yeah, that should be okay. If you're staying there and you are standing there in front of your stuff with your cheese plate and saying, here's what I do and here's how we can benefit this, then that should be okay. It's when you just drop it off and you're giving them something of value to do their business in expectation of the agent sending you the business back. That's the issue. If you're there marketing your own wares, it really should be okay because it's benefiting you as well, not just the agent. You're there to advertise yourself. What do you think about that? You think that's right, or do you have a question about that? Everybody pretty good with that one?
Looks like we're okay. You want to go into the next question here?
Sure. I don't know what it is. We might have already done it. Oh, this is a good one. A mortgage lender devises a contest among local real estate agents where the agent that refers the most customer to the lender will receive a vacation cruise to Alaska. Is this a violation?
Oh, look at all those exclamation points.
We got capitals and exclamation points. Yeah.
I guess nobody is sending us to
Alaska. I guess we're all not going. Yeah. So let's click the answer, but you all know, of course, this is a violation, right? We wish it wasn't.
Yes.
But absolutely, it's a violation. And that's one of the things that also happens frequently. You know, if you do business with us, for every closing we have, you'll get another business card of yours. It's kind of like the NBA lottery, you know, with all the ping pong balls. The more balls you have in there, the better your chances of winning. That's a violation. Absolutely. You cannot do that. That's absolutely an incentive for the referral of business. Mm-hmm. So we definitely have that one, and I see that out quite a bit. How about this? Because this is a question that I sometimes get. What about a builder that says, for every client that you bring in as a buyer, we'll pay you more. Each time a buyer closes, you'll get a higher commission. What do you think about that? And this one is a little bit contested, so I'm going to give you my answer, and then I'm going to give you some of the other answers that other lawyers have, because not everybody treats this the same way. Do you think a builder incentivizing an agent to bring more and more buyers, the more buyers you bring, the more money you make, would be a violation of RESPA? What do you think? Did anybody
I think we have a lot of people thinking about it. So far, we're kind of mixed. We have no's and we have yeses, but it seems like they're quite hesitant to answer.
Well, they are quite hesitant to answer, as are many lawyers, and even HUD actually is hesitant to answer that one. Because let's think about it for a second logically. What is the builder doing? They're incentivizing the referral of business, right? A thing of value is the commission. Of course your commission is a thing of value. So can they give you more and more commission the more people you brought in? So many lawyers, and HUD actually says, any seller or builder, a builder is the seller, right, can offer any commission they want on any transaction, right? But the bottom line here is, are they, you know, casting their net out to specific agents? Yes, they are. And that specific agent is the one who's already brought a buyer in. So that higher commission is not available to everybody. So it's interesting how the different determinations land on the minutia of the transaction. And I can't see what the comment says there. Commissions cannot be standardized, so of course they can. And that's what I just said. Any seller can offer any real commission that they want in any transaction. Each home sale is a new transaction, right? So they can. Now, if builders are in the MLS and offering a standardized co-broke and then a bonus to that agent who brings more in, that makes it a little bit more flexible. But this one causes some heartburn amongst lawyers, and many builders do programs like this, and their counsel will say, yep, it's fine because commissions cannot be set by any regulatory agency. But the incentive to refer more business might be a violation of RESPA. But here's the bottom line, in my opinion. What is a builder? Is a builder a settlement service provider? What do you guys think?
And we have a lot of experience listening. I really hope that they will answer this question.
All right, nobody's answering so far. Is the builder a settlement service provider?
And no Googling it. No, not the builder. Unless there is money due to the builder at close, no, possibly.
Okay.
It depends.
Okay, the builder is the seller. So they are not a settlement service provider. They are the seller. So it's quite interesting when you rationalize it that way. And that's, for the legal side of things, that's where my take would be. Just like any seller, in our case, the listing agent establishes the co-broke, right? The seller and the listing agent agree to what they're going to pay. But in a builder's case, typically, they're the seller with their agent representing them, and they're establishing what is getting paid all the way around. They are not a settlement service provider. If the agent said, if the listing agent of the builder, so let's say you have ABC Builder and ABC Realty is the designated broker of the ABC Builder, and the realtor said, for everyone that you come in, I'll pay you more, would that be a violation? What do you think?
Say that again.
If it's not the seller, it's the agent that's listing it that is advertising that. Would that be a violation? More and more you bring in? See, you guys are all dropping out of answering.
Yes, yes, yes. Let's go with yes.
Well, I'll tell you, it's hard, and that's why you're dropping out of answering because it is really difficult. So let me put it to you two ways. Is agent to agent a RESPA violation, or does it have to be one settlement service provider to another? Even though both agents are on there, why are two agents on the settlement statement? Because of the commissions. But only one person is receiving basically the commission, then that person's doling it out to the other side, right? So there's the argument there that even if it was agent to agent incentivizing them to bring more buyers in, it's a commission structure, not a RESPA violation. So if the builder's title company said, if you bring more buyers in, we will pay you $100 and then 200 and then 300, that's definitely a violation. So we've got a question here. I can't read that far away.
What if they hand you a pamphlet that says commission program on it?
Well, again, we're still talking about the same thing. It could be a billboard for all I care, and it's as long as it's available to everybody, which it is, even if you haven't brought the buyer in, if you bring one in, this is available to you as all agents, then it really is okay, and truthfully, it's the builder as the seller offering the incentive. So we have a lot of issues with builders and RESPA violations, and it's never about the commission. The issue with builders and RESPA violations is always about marketing services agreements. Like, for instance, Wells Fargo just pulled out of all marketing services agreements and affiliated business arrangements because nobody can distinguish what is or was not right now, and they don't want to be the one that is forever linked to the largest RESPA violation in history. And one of the big things they had affiliated business arrangements with were builders. So we're losing that relationship as builders and lenders. So I don't even know what time it is.
Got about 10 minutes.
Oh, got about 10 minutes.
We're going
back and forth.
And you're doing good on the questions.
So what kind of questions do you have? I've got things that I'd talk about, but I would rather answer your questions if you have them.
So while I'm going through the questions, Mary Frances, we talked about before the webinar started that RESPA is now enforcing these rules, and we've kind of brought on a whole new team of people or a whole bunch of new people to enforce these rules. You want to touch on that a little bit?
Sure, and let me give you an overview of the CFPB and how that's now in charge of RESPA, which, by the way, the CFPB, the largest regulatory agency ever, right, came out of Dodd-Frank, and I can't even begin to tell you what the CFPB oversees. It's crazy, and if you really start to think about it, and I'm going to talk about this in the CRMS class on Monday and Tuesday in Lake Havasu, the CFPB oversees RESPA, HUD, the FDIC. I know, it's crazy. Loan officer regulation and compensation and how that's structured. It wants to start overseeing your financial services providers and your retirement accounts. It oversees TILA. All of this stuff, which is why we're changing all of this, and of course RESPA. So with the CFPB overseeing all of those things that are related to our industries, they're now starting to look at how each of them affect the other, and that's really easy for them to find RESPA violations because they do control depository institutions, they do control titles and escrow, they do control lending, and they do control, for the most part, the real estate industry, in that is the main industry. So if there's a potential RESPA violation, it now gets investigated on a baseline by RESPA, but ultimately investigated by the CFPB, who then gets to decide. They are judge and jury. They decide whether, based on the investigation, there should be a hearing. They hear it, and they decide whether you violated it and get to decide what penalties could be assessed in violations.
So kind of what we're looking at is if we had a couple hundred violations in the past, not that any of our members would ever do this, but potentially thousands of violations because they have bigger teams working on it. They have more people. There's more eyes on what everybody's doing.
Right. And if you've ever been to the CFPB website, it's cfpb.gov, I think.
Yep.
It looks remarkably like when you have an MLS listing up and you can click report a violation for the MLS. The CFPB in the top right-hand corner has this lovely blue calming button that says submit a complaint. And it's pretty simple to submit a complaint to the CFPB. And again, we go back to that X factor. Who is submitting complaints? Who's turning other people in? Ex-employees, ex-girlfriends and boyfriends, agents that don't like that perhaps the title company decided earnest money did not go to them and their client. So they're going to click that button and say, did you know that my title company's been paying for my marketing for 2 years? That's what's terrifying about this whole thing. And they will investigate those things. And once they see that that title company paid for that agent's marketing, they're going to pull the thread and say, well, what other agent's marketing did that title company pay for? And now we've got this gigantic situation coming up that could result in a large violation.
Okay, so we're talking about marketing and RESPA violations. Now, when our members, they have that list on their website of 2 or 3, home inspectors and 2 or 3 title companies and 2 or 3 stagers and 2 or 3 pool people. Talk about, is that a RESPA violation there?
Well, not sure this is the answer everyone wants to hear. I don't know who came up with that rule of 3 to begin with. I really don't. We live and die by that rule, and I'm not sure why. I think why is the fear that if we do recommend somebody in particular and that goes awry and something happens, then people are going to come back to us. Obviously, our contract has a couple of those it's not my fault clauses in there to protect us in that, but that doesn't mean we're not going to get sued over things. So we give them choices of people. So why do you think choice of 3 versus 1 makes it any better? I'm not sure that it does. As a matter of fact, many of our agents who refer 3 people don't know the other 2. They've only worked with the 1. So if your client chooses one you don't really know, but you'd have to give 3 because somebody invented that rule of 3 a while ago, and you don't know their practices, could that come back to haunt you as well? Yes. But here's the thing. Are you demanding that your clients use these services? Because if they use those services, you get something else. So if I'm only referring 1, you can only use my lender in this transaction, and that's because my lender takes me to Alaska every year. That's the violation. The suggestions or recommendations of other industry providers are really, I mean, of course our clients are going to ask us for that, but you can't direct them to use someone. You can just give them your recommendations, people you've done business with, and they don't even have to use them. It's when you make them use it. Going back to the who chooses the title company question. How many of you filling out a purchase contract with a buyer says, okay, what title company do you want to use? We generally say, oh, well, you're free to choose any title company, but I always use this one, and I know them and I like them, and if you don't care, I'd like to use them. That's no kidding how it goes. So could that be forcing them to use our title company? Possibly. And are we doing that because our title company gives us free materials? Possibly. And that's what I would look at to determine whether it's a violation or not.
That's excellent. All right, so we're going to wrap it up a little bit here. I went ahead and put Mary Frances's contact information on the screen. Best way to reach you is via email.
Yes, absolutely.
Yep. And okay to reach out to you with questions and stuff like that?
Yeah.
And just so you know, we're going to continue the conversation at the Industry Partners Conference coming up in September. Mary Frances is going to be there.
I am.
And we are talking all things new contracts, revised contracts, TRID.
RESPA. Yeah. RESPA. We're talking RESPA in the morning, and we're talking the new closing documents in the afternoon. So it should be great.
Mm-hmm. Well, thank you. We have one more PS question.
Sure.
Thank you, everyone, for your kind words. We appreciate it. But we do invite you to the IPC coming up. Check them out on Facebook. Like us. I'm posting all the stuff on there as well. There's a couple of really great videos of Mary Frances as well. So you should jump onto Facebook. What if you have them fill out an affiliated business agreement disclosure that says we are a business partner with a title company?
Well, if you are a business partner with a title company, you must have them acknowledge your arrangement and what it consists of. But that doesn't mean that we should be requiring them to use that partner. That's where we run amok. One of the biggest cases of RESPA violation is called Lighthouse Title. That's the parties that were involved, and that's what all lawyers refer to it as, the Lighthouse Title case. And in that case, believe it or not, this is a recent case too. It's not like 40 years old. It was Lighthouse Realty owned Lighthouse Title through a separate, it was a separate entity, but the ownership was basically the same. And in their real estate contracts from Lighthouse Realty, on the title section, I think it was out of Minnesota, I can't remember, where you had to choose the title company, it was pre-printed Lighthouse Title in their purchase contracts from their brokerage. Okay, couldn't be more clear RESPA violation, right? Because you're not giving anybody a choice, and you're specifically making them use this title company without, at this point, an affiliated business disclosure. So clients, buyers just thought that's how it worked. You use Lighthouse Realty, you use Lighthouse Title, because a lot of their buyers were first-time home buyers and didn't know the process. And it was never brought to light that there was an arrangement between them and money going back per transaction. Huge, huge case. They all got violations and large dollar amount penalties. And just so you know, if it continues, and unfortunately in this case, they kept doing it. They didn't stop doing it, which is just dumb. Criminals are dumb, by the way, just so you know. They didn't stop doing it, and they got much more heavy fine on the second go round, and were actually issued a cease and desist.
Wow.
Yeah.
Wow. Well, thank you everyone for joining us today. For the
Partners Conference, we do have CE credits assigned. I believe it's 3 of contract and 3 of legal issues.
Yes, we do. So that is pretty exciting. You're welcome. You're welcome.
And if you've never been there before, I highly, highly recommend you attend. It's an awesome day.
So everybody on the webinar today, I'm going to go and check the registration for the ITC, and I want to be able to see all of your names on there. As always, today's webinar has been recorded and will be available on our website at aaronline.com. Give me about a week to do the edits and have everything perfected on our webinar, and it'll be available to you. If you have any questions or comments, please feel free to reach out to Mary Frances or myself. We're always looking for feedback. We have a full list of webinars coming up in the next few days, the next couple of weeks, so please check our calendar and sign up. Thank you again for joining us today, and have a great week.